Good morning, Scott here, known as Cantaloupe to some online, and I'm bringing another video to you on a subject that's interesting to me. It might be of interest to you or someone you know, and this is going to be a short follow-up video to the one I posted yesterday outside the courthouse, and I promised to follow up, so here it is. I just want to check in with the fact that the case has been continued again. I was offered a plea bargain, which is what they try to do. They see if they can just get anything. Long story short, the DA will press charges if they think they have any possible chance of getting something to stick, regardless of the circumstances, regardless of the possible defense. They just try everything and see what sticks. Beware of U.S. courts. Beware of your local superior court, because they are not your friend. They're not trying to help you. They're not trying to render justice. They're trying to prejudge to the maximum possible extent and just see what sticks. So, case in point, pardon the pun, yesterday I was offered a plea bargain for a supposed battery charge that happened almost last year. It's a long time ago at this point. And the accused has no complaint. Or excuse me, the defendant, the victim, the so-called victim, the alleged victim has no complaint. The situation is long resolved, and it was a dispute where this person had actually approached me, my side of the story, had approached me at a very predetermined and sensitive time and place, knowing that I would be vulnerable and not receptive to any kind of strangers approaching me. And they walked up to me, demanded a cigarette, knowing full well that I didn't smoke. And the same person had previously approached me in a similar way with hostility and obvious bad intentions on several occasions. And I had never seen this person or had any interactions with them prior to like 2 weeks before the incident. So anyway, just a little bit of background. I defended myself. I said, get away from me, and the person refused to leave, so I gave them a reason to want to leave. I battered them at that point and then reported it myself to the police. Okay, well, I don't need to be harassed by people, and after I tell somebody to leave, after they've previously been hostile towards me and they refuse to leave, I'm going to defend myself. So this is what happens. I went and told the police. Apparently somebody who was in the area also told the police, and then the police came the next day and gave me a citation. So it was a citation that, now usually when there's a citation, if you're experienced with this kind of thing, it's dismissed, or there's some kind of fine imposed, or community service perhaps, but a citation very seldom goes to a criminal procedure. It doesn't become an arraignment and then formal charges, but like I said, in this case it is. And I'm not going to go into too much detail about the types of harassment that I personally receive from the courts and law enforcement, but that's connected as well. And in this case, they offered me a plea bargain already. They said, okay, well, we'll give you 2 weeks in jail, which I have not served, so I would have to serve that. And we're going to put you on a 1-year probation, and you would confess to a battery charge. Okay, so this is completely ridiculous. So at this point, I haven't even had a chance to explain my side to the court. Of course, I'm going to fight this. Of course, I'm going to say no, thank you for the offer. I will, however, fight this. I will take it to trial, and this is where you say you want to waive time or not. The court will ask you if you want to waive time, and sometimes your lawyer will just answer for you that it's fine. And what that means is that you give up your right to a speedy trial formally. You say, I don't care about my legal rights, my civil rights, as far as getting to trial quickly. I want to work with the court's schedule. I want the court to have maximum flexibility as far as scheduling things, and not make it inconvenient, so that the prosecution has time to build their case and investigate, to share discovery, and all that stuff. So it's a gesture of good faith towards the court to waive time. It's a little bit of court procedure protocol. So I went ahead and did that because I'm not trying to fight the court. I'm not. But I am going back, in conclusion, at almost 5 minutes, I'm going back in two months, basically, to go to trial for this thing that was just patently self-defense, if anything. It was a non-thing. It was a non-thing, and the only reason it ever went to court against me is because someone, a third party, decided to take it upon themselves to report it. Between me and the person in question, the other party, there was no ongoing complaint. There was no more confusion or animosity that I know of. This person has not appeared again. They haven't been to court. since I've been to court. So it's just funny that the people of the state of California, in this case, or any state that you're in, will take it upon themselves to just press everything. This is what they do. Maybe I can get a conviction here, maybe I can get a conviction there, which, if you watched my last video, amounts to a prejudgment. It's a prejudgment. We're going to just try to prosecute you on a symbol. We're going to say that if the symbol fits what you did, out of context, before any investigation, before due process, before any kind of testimony, we're going to just go ahead and do that. And if we can get you to sign a confession, we're going to do that too. And sometimes, this time I'm out of jail, but sometimes they use the fact that you're already in jail, because if you had been arrested, if I had been arrested, I would be perhaps, wanting to get out, obviously, and then they present this offer. Oh, you're in here, and you've been in here for a minute. Well, I'll tell you what, we'll let you out if you confess. And this is how it goes. This is how it goes. So whether or not something happened, whether or not there was damage outside of an agreement, whether or not it was even good behavior, they don't care. It doesn't matter to them. They just want the conviction. The DA wants the conviction because it looks good on their record. The DA is usually lined up for a future career in politics. That's how it goes. And their conviction rate is significant. So it helps them in their career to have the highest possible conviction rate. And this is a fact. They get paid. And their future success hinges on how many convictions that they get from the people that they try at court. And they don't care necessarily about justice. They don't care necessarily about whether or not there was damage, if it was consensual, or if the law was in fact broken whatsoever. They just want the conviction. So beware. And I'm right in the middle of this process. I'm going to fight it, and I believe that I'm going to win this. I told my lawyer, I said, I understand what happens, what's going on, and it's entirely possible at this point in time that upon review and investigation, they're doing an investigation, the court will drop the case. Once they realize that it's completely ridiculous that I was cited to begin with, not arrested, but cited, and the fact that it was brought to arraignment and now a criminal process is very unusual. It's unusual, and it bodes well for my case that there was almost nothing to look at to begin with. There was no arrest. There was no police involvement the day of. It all came afterwards, based entirely on third-party testimony. And that's all it takes. Some kind of rumor. Somebody went to the police on their own who wasn't even involved the next day, and now I'm facing criminal charges for something that had nothing to do with anybody, and it's already settled. There's no complaint from the supposed victim. Anyway, something to think about. Check it in just before 8 minutes. If you have any comments or questions, reach out down below. Thank you.